Yes.
For pronouncement of judgment, item 1, matter pertaining to Kohima bench.
For the discussions made and the reasons recorded herein above, we find no infirmity in the reasoning of the learned single judge. The appeals accordingly fail and are dismissed, no order as to cause. The state is permitted to proceed with the regularization under a special recruitment drive if it has not already been completed.
I agree.
Obliged.
Bashman.
Uploaded.
Adjournment request, if any, from item number 1 to 7.
Yes.
May I please, your lordship? My lord, item number 2, my lord. I have taken the consent from my seniors, my lord.
Are you appearing in the other item? Where
My
the
lord,
item has been put in?
other item is represented by my
Who appears for the applicant?
B Chetri, my lord.
Who is the
Lord, can it be after the vacation?
Mr. Advocate General, you can proceed. There is no stay order.
We have already, I think they are happy, lordship. They have received the appointment order.
All right. All right. As prayed for on behalf of the applicants. As
Prayed
prayed
petition.
for on behalf of the applicants / petitioners. Let this matter come up for consideration. But why are you keeping it pending? We have indicated our mind.
My lord, for my personal difficulty.
Personal difficulty, I will not question.
My
It's
lord.
all right. But
Ma-
unnecessarily, matter should not be.
No, my lord, we have found certain documents and judgments, my lord.
That you said on the last occasion also.
No, that is correct, my lord. That's why, my lord, those things are.
Anyway,
My lord.
so it goes in February.
Because January lordship, they don't deserve a New Year's gift, which are dismissed. Lordship has already expressed the other day. I was telling them today.
My-
I remember only that the dismissal is going to come.
No. If he comes up with some law, something happens in between.
If we can satisfy my lord on that line, my lord.
All right. As prayed for on behalf of there is one applicant, no? Only one applicant
No, no,
and
my lord,
other petitioners.
there are several
No,
petitioners and
I'm
applicants.
talking about IEA. There is IEA in only, on behalf of applicants / petitioners, let these cases come up for consideration sometime in February.
9th of February.
My lord. Obliged.
That was from on a lighter vein, I have said,
No,
lordship.
no.
Obliged.
Mr. Bhuyan knows that he
Look,
doesn't
we
have
have
any
wanted
point
to divorce his friend today. I said that they have to restore that petition for restoration of conjugal rights. Because
My lord. Obliged, my lord.
May I please, Lordship?
Yes.
So I beg to mention item number 6.
6.
6, Lordship. I have the consent of other
You are for the
appeal petitioner, Lordship.
the Union of India.
Yes, Lordship.
Why do you want it, gentlemen?
So it will be taken up next week, any date, Lordship.
Next week is only 5 days.
Tuesday, Lordship.
As prayed.
My lord, there is a stay against the tribunal's order. Matter is very small.
That's right. But
Otherwise, I am.
prima facie, we find some merit in the
Yes,
contention
yes.
of the petitioner.
Yes.
So therefore, don't insist
Hmm.
for anything else. If you want to argue, I mean, we have
She is
Yeah, Tuesday it may be taken up.
as prayed for on behalf of the petitioner, re-notify. And this is against law, what the
Yes.
tribunal has said.
Yeah.
We are not saying this. Supreme Court says this.
Yeah.
My lord, 44B of the engineering, Maharashtra engineering,
No law, no act.
44B.
As prayed for on behalf of the petitioner / Union of India and 3 others, the matter is adjourned to February. You've got your promotion, it's all right. You've got your selection in the higher grade of upper division clerk.
Yes.
Right?
But seniority in the Melody.
Seniority, forget it.
No,
The
no,
difficulty
difficult-
would be they can even insist that you can't be in service.
Yes.
I mean, yes, you can be because your services have been regularized in 2000. All right.
2nd February.
Obliged.
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 Adjournment request from item number 39 to 46.
May it please your lordship, lordship, in respect of item number 42, lordship, Mr. Gupta is appearing in this case for Union of India, lordship. There is some difficulties, he is not here out of station, lordship. So lordship may,
As prayed for on
Lordship,
behalf of
Lord-
the appellant.
Lordship, I am appealing for the respondents. Lordship, on the last day, 21/8/2025.
Yes, yes,
this
we
honorable court
remember.
Made an observation that there should not be an adjournment in this
Yes,
matter.
I
Lordship,
remember.
it is a long pending
I
matter since
remember the
2007.
face of the advocate because of you wearing studs.
Lordship, there are 150 families. Lordship, our lands has been acquisition. We are
And
four
I'm
farmers.
doing something else.
8 years
in-
since we dug. this is
Instead of
pending before-
responding to what the court says, you are talking something else. Now, we can't give a long adjournment.
lordship, lordship, any day, lordship, he is,
Lordship,
There is some
kindly-
personal difficulty of the lawyer who is to appear for Union of India.
Lordship, they always have a difficulty when the hearing is.
then lordship may take his part, lordship, our part, any
No, no,
other day,
lordship,
lordship.
our
If
part
he-
may be
if
hard.
he-
Lordship,
if
our
he is
part may
any
be hard,
difficulties, lordship.
Can't be. The appellants have a right to argue, no?
Lordship, the 150 families come to my chamber always, they they chaos in my chamber.
He is also having some problems.
Lordship,
Next week, would it be possible?
Lordship, lordship, any- today he is out of station, lordship. Today.
Lordship, our part may be hard, Lordship.
Or, Mr. Counsel, please don't insist for something which is beyond the procedure. We can give a short date which we are not giving to any other case. Considering the observations that was made by this bench on the last occasion while adjournment was sought, we are considering it for next week.
Right.
Next week shouldn't trouble you.
Lord.
All right. As prayed for on behalf of the appellant / Union of India and others, let this matter come up for consideration on give a date
16, next week,
next week.
16 February.
Lordship, lordship. Obliged, lordship.
15 December.
16, full of.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 45.
Yeah, adjournment slip circulated with the consent of the party. March.
Much obliged, lordship.
10th of March, 10-3.
Much.
Any other request?
Yes, your lordship. Lordship, I request for listing of a urgent matter tomorrow in the writ of habeas corpus. Actually, in this matter, the petitioner's son has been missing from 29/25.
Tomorrow.
Obliged, lordship.
Daily list for admission, item 3.
Here, madam, I prefer further time to file the affidavit in the matter. I file the affidavit.
My lord, in this case, I file I also, my lord. And you know, if that takes the time. Yeah, lordship has given us a liberty in order to participate in the tender process.
Just a minute.
So in the tender process, there is a condition.
1 minute, sir.
Lordship.
ये भी पढ़ने वाला का खुद that's what is not time. This is by umpiring. Appeal also by umpiring. Just. Perfect. नहीं हम
Police, division multi order. 31 दिया.
Yes. What do you have to say?
My lord, in this case, lordship has already, while issuing the notice, my lord, given us a liberty to participate in the tender process, my lord. So in terms of it, NIT, my lord, we have to visit the site and obtain a site visit certificate from the concerned engineer of the department. My lord.
For participating? in the-
Department of Personal accompanied me, my lord. They did not give us any certificate, my lord.
Why?
Lordship, then we approve this honorable court again, my lord, by IA. That my lord will find. That my lord will find that page, my lord. Page, my lord, there are page 64, my lord. Start from page 64.
can't
my
happen,
lord,
no?
from Mr. Nissi.
The work has been put to retender.
Yes, my lord.
That is what he has questioned.
Yes,
Now, if he has been asked to where,
my
have
lord,
we
my
said
page
that-
24, page 24 of your lordship's order. It's a Page 24, your lordship. order.
এইটো আইটো মোক দিয়া নাই এইটো। নতুন আইটো দিয়া নাই, এইটো আইটো নাই। নতুন আইটো দিয়া। নতুন আইটো
আইটো দিয়া নাই।
নতুন আইটো লিষ্ট তাকেটো আছে। নতুন আইটো
দিও নাই নেকি?
নতুন আইটো লিষ্ট নালাগে।
আমি লিষ্ট এইটা কোথায়? নতুন আইটা হয় নাই নাকি?
লিষ্ট
কি করো বুঝে না। তাই not there.
yes, where is the IA? We will get at which page?
My lord, 3898, my lord.
3898.
998.
IA, yes.
My lord, sorry, my lord, there's a listed, my lord. I am sorry. That is the problem. Lordship may take up next week.
I don't have the copy.
Give him a copy.
Yes, my lord, next week, my lord.
He could not have filed that application without serving.
Oh, I saw the copy, my lord. RFC so received.
Mr. Nath may not be having it, but his
Yes,
office
my
has
lord, I'll
received.
today, my lord. I'll file.
All right, you can't prevent that, Mr. Nath.
That's true.
Yes, my.
Lordship has
And
directed-
division
Lordship has
bench also
passed an order.
passed an order, my lord. Till thereafter also they did not furnish any certificate, my lord. They were from us from
The
participant.
appellant has filed an application of bringing to the notice of this court that notwithstanding the liberty granted to him to participate in the retender, he is not being provided with the certificate of his having visited the site, which is an essential requirement for participating in the fresh tender. However, it appears that the interlocutory application filed on behalf of the appellant has not been listed. Mr. Ghosh, learned advocate for the appellant applicant, is directed to serve a copy of the IA to Mr. Nath, learned counsel for the respondent, during the course of the day. Let this matter come up for consideration give it on next week, Tuesday, Wednesday, Thursday, anytime,
1712.
Obliged also, deeply obliged.
along with the IA application.
Lordship.
3898 is there. Item number 4.
Who appears with the petitioner?
The petitioner is in person in one of the advocate about
So therefore, it should be he or she. He or she. He should be here.
my lord.
Nobody appears on behalf of the petitioner on repeated calls. Do we dismiss it? This is for the first time. Last time,
Last time he was there, year before he was not there, my
who is
lord.
this advocate? Fazlur Rahman.
Yes, my.
Yeah.
We have filed our affidavit in this case.
Nobody appears on behalf of the petitioner on repeated calls. Let this matter come up for consideration sometimes in March.
Obliged.
11 March. Item number 5.
Yes, Mr. Chaudhary.
My lord, that my learned friend is to say something, my lord.
you will have to depend on the mercy of the.
My lord, my lord.
Nothing. We can't. do
Yes,
anything
madam, I'm on
more.
mercy of them.
We can't do anything more than this.
Lordship,
My
I
lord,
have a
I-
positive, Lordship, positive suggestions, Lordship.
Hmm.
That in case of all other muster roll workers
Hmm.
who are contractual, whose service is contractual in nature, we can give them same benefit. They will continue to work till 60 years. As per the recent judgment of the Supreme Court, not recent, I mean 3-4 years ago, that the last pay scale, and at the time of superannuation at 60
Put
years,
it on record, Mr.
we'll put it on record.
Put it on record by the,
Yes.
by next week, we will dispose of. this.
Lordship. So they will
Are
be
you-
benefited.
This is a windfall gain for you. Mr.
Madam,
Chaudhary.
positive, I am,
This is more
but I
than
am
what I
thankful
had
to him, my
expected
yes.
the Advocate General to do.
Madam, I am not disputing that, Madam. I am thankful to him.
Put it on record, he will
Lord.
press this petition.
Lordship.
Why we are saying this? Because you never know Mr. Chaudhary's clients. Now, after some time, they will go for regularization. So with consent order, we will consign this petition.
Lordship.
Put it on record.
Lordship.
Otherwise, again, another litigation after 4 years.
Yes.
See, considering the starting paragraph of Jago, that this should not be done and there should always be regular employment and all that, they will come back to you again. So
Your
put
worship
it on
already
record.
mentioned last order, my.
We will say whether he consents to it, we will consign this.
But the only thing, madam, only my line.
Nothing, Mr. Chaudhary, this is more
Yes,
than
yes,
what.
madam,
he
I
had
am not
expected.
disputing. Only thing, madam, they are not masterable, madam, contractual.
And
Contextual.
Yes, yes.
Mr. Advocate General, I must tell you that we will not be insisting for this in any other case. This will
Lord.
not be a precedent. Don't
Yes.
worry about it.
And one
But
more thing.
This
uh,
this we wanted for the reason that these are all experienced hands.
Lordship.
And there is an agreement between the state. There is a memorandum which says that you shall make them permanent.
Lordship. I have
And therefore you can't come out of that.
absolutely, Lordship. And one more thing, there were 8 writ petitioners, and in the appellate stage, there are 4. So whether Lordship will give that benefit to the appellants only?
Yeah, to those persons also.
8,
Only 8.
only 8.
11.
Just put
11. 11, Lordship.
whichever is the number. Just,
Now here, before this honorable court is only 4.
no.
2011.
Otherwise, again, we want to stop
They will
Yes.
come for parity.
Yes.
parity.
They will come for parity.
So
I
that-
advise to all.
and we will specify that under these circumstances, nothing more.
Lordship.
So that others do not raise their heads.
Lordship. Highly
I
obliged.
will also not ask for anything more than what he says.
No, you can't vouch for your clients, no? They will engage another lawyer and come back to the court.
Obliged to us.
Deeply obliged.
Let this matter come up for consideration for final litigation.
Date may be next day, only 1 week. Next week, the
Let
one
it be on 19th, Lordship, the last day.
On 19.
there is no problem. Thank you. থাকিব লাগে, দিব পৰা লাগা হয়।
1912. আপনি বহুত চলাব আছে। চলাব in a positive way.
Not, बीच इसमें टाइम लिया था घोष वाला
विजय कुछ
मेरा लिखा हुआ है उसमें
Obliged.
supplementary list item 47
Deeply obliged.
Great preserve. Well, Lord, here in this case, only one point is to be decided by your lordship. Whether a bidder without filing bank draft necessary for tender submitted the bank draft in the name of another person. And that point has been
now
decided.
you're framing it in a different way.
My lord,
The endorsement was to the authority concerned,
my lord,
but by a different person.
different person.
And there is a judgment of this court,
Yes, my lord.
Deori or something,
Yes, my lord.
which is
Yes, ma'am.
which is holding the field for a long time.
My lord, that's all right, my lord. But I am before your lordship,
Yes,
I am before your lordship challenging that decision of this Deuri, the case of Deuri, my lord. Because is it a right decision? That point will be considered by your lordship.
That point is
My lord,
arguable.
it is
You're
decided,
right. That point is arguable
my lord.
for the reason, not
Right.
for any other reason, but for the reason that what is an essential part of the tender paper,
Yes,
deference has to be given to the decision of the authority.
yes,
And court should not substitute its opinion.
yes.
That is the only question. But in
Well-
this case, now considering the fact that you were the lowest bidder,
My lord.
you were the lowest
That-
bidder,
that is another
and the
point.
respondent who was the writ petitioner,
But that is
he-
another,
that's another issue, of course.
that is another issue, my lord. But your lordship would consider whether somebody submitted bank draft for somebody else, my lord. And that is has been decided.
Again, we have some objection to this framing.
My lord.
The draft was made by Bijitra Brahma,
My lord.
not Paresh Brahma.
Yeah.
Correct?
Yeah.
But it was payable to the authority, the
Yeah.
correct authority.
Yeah.
And therefore it was found that it was not so essential, it was not such a breach
Correct.
that the highest tenderer should be avoided.
Correct.
Now this we have been able to smell rat here. You are even lower than the second, third, fourth.
My lord.
I don't know how BTC.
Lowest,
the
lowest is all right, my lord.
BTC is-
My lord, here, my lord, I want to point out one thing. I am lowest, no problem. In between, my lord, in between the read petitioner and myself, my lord, other bidders are defective.
So therefore,
It has,
you- only two
if
of
that bank draft issue is taken into consideration, definitely I will
Mr.
get this.
Mr. Sheikh,
My lord,
now you know what is the cut price at what he has overstretched himself.
Right.
The respondent number one has overstretched himself.
Right.
So you know the base price now.
Right.
Participate in the tender.
So,
So
my
it
lord,
has been given to him.
my lord,
It
my,
has been given to him.
not,
no.
my lord. Not,
Lordship, there's a change in the government and the earlier board has been changed. Now there's a processes on your lordship for initiation of the process,
lord.
this on my lord tender process.
My information is this, my lord, till date it is not given.
So
I
doesn't
think
matter.
no one has been.
We are not interfering on this ground alone.
My lord.
Take it. Have you noticed, have you issued notice to the respondent number one?
No, your lordship, for the first
Not
time.
necessary. If you are dismissing, it's not necessary. We have heard Mr. M.S. Sheikh, learned advocate for the appellant, and M.S.B. Bhuyan, senior advocate,
APR
assisted,
for BTC, assisted by R Das, my lord.
assisted by Mr. R. Das for the BTC.
Right.
A public tender process was initiated for the annual settlement of various local markets, ghats, parking lots, ferries, and cattle ponds in Buxar district in the state of Assam for the financial year 2025 to 2026. The tender was issued by the block development officer of the concerned block under BTC. The issue here revolves around the tender for Barimakha open market, where the reserve bid amount was fixed at 1,64,096. Appellant and 4 others, including respondent number 1, had participated in the tender, where the respondent number 1 had offered the highest price of rupees 4,315,000. And the appellant, the respondent likha na? Did I respond? And the appellant had offered the lowest price in the tender, even below the reserve price.
Not below the reserve price,
It was not,
above.
yes, it was below the reserve price. Even below the reserve price,
Not below, my lord.
sir, we are telling you, no? For 1,07,060. Is this not below
70,
1,64,000?
1,70,000.
1,70,000. Acha, not below.
Not-
1,70,060. Next, despite the respondent number one being the highest tenderer, the contract was given to the appellant on the ground that the tender papers of respondent number one suffered from a technical breach of the terms of the contract, terms of the tender paper, namely that the demand draft submitted by him, though was endorsed to the correct payee, but the payer was not the respondent number one, but somebody by the name of Bichitra Brahma. Respondent number one challenged the aforementioned decision of the appellant having been given the contract despite being the lowest tender, which challenge was sustained by this court. A learned single judge in WPC number
4753.
No,
4753.
all right. Elika? In WPC number 4752 of 2025, allowed the petition following the judgment, following a division bench judgment of this court, division bench, following a division bench, following a judgment of this court, following an earlier judgment of this court, passed in WPC number 7889 of 2022, bracket Karuna Dev versus State of Assam and others. It was held that the demand draft paid by respondent number one was valid, notwithstanding the name discrepancy, as it was in favor of the authority, and that such deposition of the demand draft did not cause any prejudice. Thus, the settlement in favor of the appellant was quashed, and the BTC was directed to reconsider and settle the market afresh in accordance with law. The appellant was given the liberty to seek refund of his bid deposit from the BTC. Mr. Sheikh, learned counsel for the appellant, submits that deposit of a proper draft was an essential condition for the tender, which essentiality was considered by the authorities, and therefore it was not appropriate for the learned single judge to have said, notwithstanding a presidential, notwithstanding a precedent of this court, that it did not cause any prejudice. It has further been submitted by Mr. Sheikh for the appellant that all other tenderers in between respondent number one and the appellant did not qualify technically, and therefore only he and respondent number one were in the fray. So in that case, the learned single judge ought not to have substituted his opinion about the essentiality of the tender requirement which was otherwise considered by the authorities, by the tendering authority. Tendering authority. There could be some force in the contention of the learned counsel for the appellant. But considering the entire set of facts, including the respondent number one having offered his tender at a very high price compared to that offered by the appellant, and the fact that after the decision of the learned single judge, a decision has been taken to put the work to re-tender, which according to MS Bhuya, learned advocate for BTC, is in the process. We are not inclined to interfere with the judgment of the learned single judge. For the reasons stated above, the appeal is dismissed.
Obliged, Your Lordship.
Item 48.
Please, ma'am. The petitioner finds himself in a very precarious position. So he is the suspended director of the corporate debtor that is currently facing liquidation before the learned NCLT Delhi. So while that is pending, that particular gentleman has now given a scheme of compromise and arrangement for revival of the company. My lord, it is pertinent to note that this particular entity before Delhi NCLT is a MSME. So there are certain safeguards that even at this belated stage, at the stage of liquidation, he can pursue this particular scheme. If the scheme is today approved by the creditors, it will lead to the revival of the company.
IBC code.
Please. But today, if that particular scheme before Delhi NCLT is approved by the creditors, who is also before this court as respond number 2, that is the only admitted creditor, the Indian Bank. So in that case, the bank will get their money. I will get to revive my company, but all of that will fail today if the NCLT proceedings of Guwahati concerning the PG insolvency process is since invoked. Now what has happened, my lord will see annexure A1 at page 19. That is the order of.
Tell us the facts and then we'll.
Yes.
And we'll get back to this. We
Yes,
have
sir.
some preliminary objection to
Please,
your
please.
petition, but then let us hear you first.
Please, I'm so obliged.
Hmm.
So before the learned NCLT Guwahati, the petitioner is since facing personal guarantor insolvency proceedings. In that, there is a fear of the attachment of his assets. Now, those assets.
Those are factually incorrect statements.
So, my lord, I'll show it. At
See,
page,
the moment that proceeding is kick-started,
please.
there is a temporary moratorium,
That's right.
right?
Precisely.
And I did not allow you to complete your arguments because prima facie, we find this petition to be not maintainable.
I'll satisfy, my lord. I understand the challenge that I have. My
You
lord,
are-
today- yes.
Therefore, before going to this, now you have to tell us about 3 aspects of the matter.
Please.
Number 1, this is a petition under Article 227 of the Constitution of India.
Precisely.
Now, why do we interfere if the tribunal is working on its plane? And then that apart, let us see 62 of the IBC code.
Let's go to the IBC.
Now, we were a bit surprised when this petition was filed under Article 227, especially when you have impugned one of the orders by the resolution professional asking you to deposit, to submit a plan.
Repayment plan, that's correct.
Well, that is absolutely.
I'm just seeking the liberty to apprise my
Unnecessary.
lord.
See, at best, you could have gone under 226. There also, we would not have been able to sustain the petition for the reason that we would have said that the remedy lies before the appellate authority there.
Please.
You can't. So you conveniently and very intelligently, of course, we commend you for that. You filed a petition under 227 for superintendents, and you have stopped the court from proceeding further only on the basis of your averments
Please.
in paragraph. Now, it was a short, well-drafted petition. which I saw in the morning, and then I tell you, this paragraph is the answer why we are not inclined to entertain.
Please, my lord.
Paragraphs 19 and 20.
Please, my lord.
Just read those paragraphs.
Yes.
Very conveniently drafted
As a,
to prove your case, but then
there
there is a boundary wall in front.
I understand the challenge, but my lord, what I am trying.
No, let's
Yes,
read the
I'll
paragraph.
just read para 19. As a consequence, the petitioner presently faces 3 simultaneous proceedings initiated by the same bank in respect of the same debt, namely liquidation proceedings against the R3 corporate debtor before a learned NCLT Delhi, insolvency resolution proceedings against the PG before the learned adjudicating authority, and recovery proceedings before the learned
Right.
DRT.
So therefore, you have specified that these are the 3 proceedings. Now, what is pending before NCLT Delhi is the CIRP.
Precisely.
Because that resolution failed, it is under liquidation.
Precisely.
Your properties are mortgaged with that property.
Indeed.
There is a moratorium there. Correct?
Correct.
This fact you have brought to the notice of the NCLT Guwahati.
NCLT Guwahati through the RP.
Through the RP.
Through the
You have
RP.
brought it. But still RP says that you provide your plan.
That is where
That is
the
where-
anti-grievance
that is where
lie.
the grievance lies.
Yes.
And third is DRT, you're not concerned with that. Now, under 227, can we look into it? Number one. So this is not basically a challenge against the order, against the insistence of the resolution professional asking you to submit a repayment plan. But 3 petitions at 3 different places where you are involved. So
Yes, sir.
whether this 227 petition would come before division bench, that is another question.
No, I understand. I understand.
And therefore, we are
But today.
Yeah.
With utmost respect, my lord, I say, with utmost respect, that the petitioner today has no other forum to agitate these grounds, because on one hand,
where is
his
the,
particular.
why do you want a forum? Then let us
Yes.
section 62
Yes.
and 128.
Before that, may I be permitted?
Just a
to-
minute, let
Yes.
us, because these are, you know,
253.
self-contained code with a specific, you know, a purpose-specific architecture,
Precisely.
right? So it is permitted. Now, 227 could have been used. Suppose I was sitting as a single judge. 227 could have been used for different purpose. If a tribunal acts patently against law, fundamental principles of law, 227 is there to correct it. 227 is also there to correct, you know, all right, you can argue that against an order passed by a single judge under 227, no intra-court appeal lies. Therefore, because this matter pertains to the NCLT, therefore division bench. But that is not the manner in which we will entertain the petition.
I understand.
So now let us see 62, just for the benefit of you. 61 has 62. What is that provision which says that every no. Then I think I'm at a different. Let us see 128 then.
Very-
No. Which provision says that these are independent proceedings against personal guarantor, another proceeding, against the corporate debtor, another proceeding,
Yes,
and debt recovery is another proceeding.
because the CIRP against the corporate debtor is pending in Delhi, as the company is incorporated in Delhi, but the person is within the jurisdiction of this
What?
court.
No, we are
And
not
that is
asking that.
Yes,
Can I have your name, please?
Nishan Das.
Mr. Das, we are not asking that. You know, we are convinced about the jurisdiction.
Please.
There is no difficulty. Now, there you are, the moratorium has been given as a full moratorium. And resolution professional, the interim resolution professional has been removed, or he has been made the resolution professional.
He has been made the RP. Now it is before the liquidator.
Now it is
Now
before
there
the.
is a liquidation proceeding,
All right.
because the Indian bank
So
would not
therefore,
recover.
here,
Yes.
any plan that you submit would take note of all that. Because here the RP would look at your properties, collate all information, and it is your plan which would let the RP know what are your assets.
At Annexure 7,
We are not entering into that merit.
right, my lord,
We are only on our jurisdiction under Article 227 to direct that please hold on. Please wait for the NCLT Delhi. We can't.
my lord, the only question that I put to myself is, Indian Bank is the only admitted creditor. Today, by virtue of either the PG or the CIRP, they are going to recover their dues against my assets. The only reason why I'm fixated on pursuing my remedy there is because it will revive my company. Here, there is no revival. My assets are only going to get attached,
That's all right.
and that will put an end to everything.
See, every authority under the code knows the basic thumb rule principle that resolve first, liquidate later.
Right.
It's only for this that the code was brought into existence in 2016.
Correct.
So you
That is the only small
now
opening.
Let her pass an order, but we have no authority to interfere.
Today, that is the only, I'm so obliged that my lord has pointed out regarding the revival and the whole objective of IBC.
Yeah.
My lord, today, that is the only opening why I have taken the liberty to come before my lords, because today, in case the bankruptcy proceedings against the PG is since invoked, that automatically fails. The proceeding.
No. You're not the only personal guarantor, or your property only is not the assets of the company. You can't say that.
But it is factually correct to state that there is no other assets for revival. My lord, I will just show the compromise.
Then I think, what was that company? High-rise.
High Rise, it's infrastructure-based company. There was this particular project
Help
that,
it, sir. Mr. Das, we can't help it. We are jurisdictionless here. You are talking about jurisdictional overreach of the NCLT. We say that we do not have the jurisdiction to deal with this matter, especially under Article 227. We could have permitted you to file it under 226 and 227, challenging that order, but then the remedy lies there. We will be dismissing it, so it's saying that, I mean, tentatively we are of the view that there is no jurisdiction. We'll be dismissing it because every authority is acting on its own axis. And nowhere in the court, if you can show that these parallel proceedings cannot be initiated.
no, that I'm not even trying to prove otherwise.
So therefore,
But that is the
therefore,
established
how
procedure.
how would this court get jurisdiction to question the order of the RP? You understand our
Understand.
problems. We understand you. We thoroughly understand you because the whole purpose of resolution first would be given a 6. We understand.
In that case, may I be at liberty to withdraw this and pursue the other remedy under 226,
Correct.
read with 227?
26. That will again, hit the road, hit the block, hit the stone. No. Before the authority NCLT overture.
Well, NCLT right now will not, in my respectful submission,
yes,
will not
so-
have the power because there is no per se impugned order. Today, my scheme is under court consideration.
That is
That is the
the
reason why.
reason why we are loath in exercising our jurisdiction under 227. We'll just say that at the appropriate time, you may agitate before the concerned.
Well, that liberty is fine. I'm so obliged.
You've drafted your petition very well. It made me think for a while.
I'm so obliged.
Mr. Nishan Das, you are practicing here.
In Delhi.
Mr. Nishan Das, learned advocate for the petitioner, after some arguments, seeks permission to withdraw this application in order to approach the appropriate forum at an appropriate time when the need would so arise. Dismissed as withdrawn with the liberty of force.
So obliged. So obliged.
This is right. Yes.
Item 7 to 38 for hearing.
Yes.
This is a appeal filed by the state of Assam Lordship on the point of a particular clause of the policy relating to compassionate appointment, which was issued in 2015 and it was abandoned in 2017. Subsequently, another policy came. in that policy, there is a condition.
The policy does away with, the new policy does away with compassionate appointment. You are talking of pension.
We are giving full. If the person dies today, he has 30 years of service.
Then why this challenge?
This challenge is because this person died prior to 2014.
Okay. And
So-
this, your scheme is?
Our scheme of 2015 to 2017.
No, your scheme, the new scheme of family pension?
Yes, it is from 1st April 2017.
So,
Not only pension, they will get the salary also, had he been alive.
right. So that is a very good.
That is there is no
that's-
dispute. Everybody is entitled. Otherwise, we have
It's an
25%
excellent policy,
lordship.
excellent policy. You save a lot of money and you save a lot of litigation.
And a lot of families also, lordship, we saved.
Yeah, you're right. A lot of families. Till the time he would have served.
And after that, family will get the regular family pension also, wife,
Excellent. I think that's a
as if he is alive.
very well conceived of scheme.
Lordship.
So this you came in 2017. So these litigations are before 2007.
2015.
These are before 2015.
Yes, before 2017, some died in 2014, some died in prior to that also. And the cases were decided, rejected by the various committees in 2018 and 19, when this policy was not in existence. Number one, and this condition which the learned single judge found to be in violation of Article 14. In my humble submission, it is not. And in any case, the present law is well settled. The law which is settled from last 2 decades, that there should be immediacy, that immediately the family.
That's right. That's
Now, if
that is the point on which you can reject such petitions.
yes,
But not making them eligible on the ground of 3 years, if the death must take place 3 years before the retirement,
yes,
this does not appear to be constitutionally viable. Nobody can predict death. And say
By that time-
say somebody dies
yes,
when he has only 2 years, 11 months left.
lordship.
So it's such inflexibility.
There, he is already entitled for family pension. His family will get the family pension
That's all right.
immediately.
That's on a different plane. But look at the rationale of the learned single judge when that part of the scheme was set aside. You're questioning that.
Yes, lordship.
Now we will say that notwithstanding the notwithstanding the quashing of that part of the resolution, not that part of the notification or scheme. What will be tested by the employer is whether the immediacy for giving succor is over.
That is general perception now, lordship.
Yeah.
In fact, it will be a case of lordship, the operation is successful, the patient will die. Because there is no question of having immediacy now. The learned single judge in 2006 itself, my Lord Justice Ranjan Gogoi, he laid one case that is throughout we are following, that after 2 years, there is no force of that application. And the Supreme Court in this recent judgment also said the same thing.
The judgment by Justice Dipankar Datta. Where is
No,
that?
not Nagratna authored the judgment, and Krishna Murari and B.V. Nagratna, they delivered the judgment. State of West Bengal versus Develpata
That's a
Tiwari.
Judgment which incorporates everything.
Here also several guidelines are given,
No, the last one, which is by 3 judges bench,
lordship. That I am not sure, lordship.
authored by Honorable Justice Dipankar Datta, very recent.
Then lordship, let me go through that judgment and come back, lordship.
See, look at this. We agree with you in principle that even though persons have come out of that trouble, they would require, because compassionate appointment is
Not a right.
not a right, not a vested right. And if they have been able to survive for 10 years, 15 years, I don't think that cases could be considered. But the logic on which the single judge operated, that is
Lordship, I'll argue on that, lordship.
all right.
The other side may not be present, and today I'm not fully well to go
Okay.
for a long term here.
No,
Because we want to argue that point also.
But would it not be only academic?
In that case, Lordship may close this chapter. I
is not-
fully agree. Yes, Lordship.
Academic,
Yes, Lordship. For academic interest, Lordship, there is no point of wasting court's time, Lord.
that's
Valuable
what I
time.
said. So we will say like this.
Yes,
That we will dispose of all these petitions.
yes, Lordship.
Saying that in view of this policy and this judgment, the learned advocate general does not press this appeal as the law is very clear that the immediacy in the matter gets extinguished and
Lord.
there can be no implant.
I am more than happy, Lordship.
Then consider, then we are not.
They will
questioning-
consider and on this point.
Hmm.
Absolutely.
We will
fine.
hold this. Please find out that judgment. We will fix it for orders tomorrow or maybe Monday.
Tomorrow is Friday, Lordship. Let it be tomorrow, Lordship.
Tomorrow.
Here also that principle is laid down in this case also.
Can you give that to us?
Yes. Paragraph
Mr.
2025.
The problem with us is the reasoning given by the learned single judge appeals to us. But then why do question that? Why do question that unnecessarily?
Because there are two parts there. There are three components.
इसको क्या करो?
2025 5 SCC page 712.
इसमें और वो एक दीपंकर दत्ता का निकाल लो, इसको निकाल के इसकी फोटो करके हमें दे दो.
The guidelines, Lordship, the final opinion is given in paragraph 36. no? 36. No, 36 no. No, 36 no. Would the point did Yes.
I think we will post all these cases for judgment tomorrow.
Lordship.
No, not judgment, for orders tomorrow.
Lordship.
I think the list is going to exhaust today, so we will get time to write all this.
Lordship, the relevant paragraph will be the point could place a BBC letter. 30, 33. No, 33, 32. Upon consideration of the aforesaid decisions, this court laid the following principles emerge. Paragraph 32.
32.
And on the point of passing of time, Lordship, elapse of time, that is paragraph 35.
And we'll make the reference case to be the first case which is listed.
Lordship. Because in that case, first case is if it is Deepak Gogoi. No, Bhaskar, Deepak Gogoi is the case I am. And the learned single judge is kind enough to give the date on which the person died. So all these dates are available there.
All the dates there.
Yeah, almost 15 years, 16 years, or some case 20 years have also elapsed. And in few cases, the dates were not given by, provided by the petitioners themselves.
All right. We have heard. And who appears for the respondent? Other respondents?
I mean, I think 8 May. I think
Please inform the advocates appearing in other cases for respondents. This shall be, we will give you an opportunity of arguing tomorrow also. But for all practical purposes, you have heard. You have heard the deliberation in the court, no? So we will be closing all these appeals on the basis of Supreme Court judgments. So you are not put to any disadvantage. This scheme of 2015 will be operative because death takes place before 2015. But the principles of law on which your application will be tested has been decided.
Yeah.
So we will say. And now that also goes. I mean, because if you apply, would you give that privilege the after 17?
No.
No. Because that cutoff date is fixed.
Cut-off date is there, Lordship.
There, above that, we take.
1/4/2017. We have given a retrospective effect to that policy also. The policy actually came in September 2017 with a retrospective date, cut-off date of 1/4/2017.
My brother is saying, I mean, considering that he is born and brought up here, he says that if this policy is made retrospective, not many persons would be there, then half the litigation in this court would be over.
Now there is no litigation. These are all old matters.
That's why
These are the legacies we are carrying.
In between.
We are carrying legacies of compassionate appointment as well as education departments, non-payment of salary. These are the certain very heavy legacies we are carrying.
you consider their cases reject, then again they will come here. That is the difficulty.
But after 2017, we have completely abolished, my lord. Now there is no compulsory appointment.
So these are the only cases which are.
Yes, but
In between those
it comes in batches.
14 to 15, I think. 14.
Even 2 months ago, I argued one case before my lord Justice Michael. 40 cases were disposed of. Now appeals are coming. We have framed a policy on Tathagata. This
Therefore, Mr. Advocate General, in that matter, Burn Hospital, we said that put it on record, we will have a consent order.
Lordship.
No, therefore, but Mr. Advocate General, you will have to concede on that point that we will not interfere with that judge. You decide according to this, we'll make it very specific.
Yes, that is why I'm not arguing. I decided back because that will be basically on academic. That on that point I am conceding, Lordship.
That we will say that.
Yes, Lordship.
We'll say that.
Yes,
that
it will
you
be
are-
a purely on academic interest.
you are
That point.
consenting to our allowing that judgment to stand in the records, but because it becomes academic.
Yes, that's why we are also not
so
arguing.
Given the indices on which you will decide such application, so if there is a delay, you will not decide.
Either way, whether that provision is there or not there, but that clause,
So they will.
it will be immaterial, Lordship.
Immaterial now, exactly. We are keeping it for judgment, nahi, orders
Orders tomorrow, Lordship.
tomorrow.
Highly obliged.
We have heard Mr. Advocate General for the appellants in all the cases. And the learned advocates for the respondents in all cases. ये दे देना मेरे को। अभी लिखा था। वो भी वो no, this is not. ये उसके पहले है 24 पेज का। देख कर तो निकाल। ये भी दोनों हमारे। ये हो गया कर। Yes.
Item 39 to 41.
My learned friend is appearing, my lord.
Yes.
In this case, Lordship, we have received the final report of the Commission for Review and Assessment of Problems of Satra Lands in Assam, a committee constituted by the Assembly that we have received yesterday. So I would like to file a short affidavit. What are the findings in the final outcome?
That's all right. That will control the facts of this case. But the problem is that there has been some misunderstanding with respect to the judgment of the Assam land. What is that?
Assam Land
Board of Revenue. Assam Board of Revenue says that there is no dispute that this is not a
Satra Land.
Satra land. It was understood later that there is no dispute that it is a Satra land. It is not a Satra land, something like this.
So I'll argue, or I'll make those submissions.
As prayed for on behalf of the learned advocate general who appears for the respondents in these matters, that he will let all the three.
Three.
All the three cases be listed for final determination. February, Mr.
Lordship,
Nothing is going to happen in the meantime.
nothing is only the worriedness about the before the learned single judge. That's the only one.
Division bench has kept it for,
My learned friend, Mr. Rajiv, is there.
we
So
can
that's what I'll tell.
make
But
that statement before the learned single judge. I'm sure we are not going to restrain the single judge.
No,
from
I know
passing any
also.
order. But then the parties can very well intimate the learned single judge that the matter is pending before the division bench and a date has been fixed. In this matter, Advocate General is appearing. It will be finally concluded.
Yes.
Thereafter, the single judge would have an ease of business in dealing with the matter.
I will definitely communicate. But could it be in January, Lordship? Yes, no problem.
Okay.
Maybe 9th or 9th. No, for me, there is no problem. 9th of January, Lord. Because there is some urgency also for the state.
All right.
9th?
9th.
The Thursday? Highly obliged. 9th. And already,
Oh, they say that it is the last day before due. So
no, this is not the last, I'm just sorry. Oh, I saw the previous years.
Oh, most are super late too.
Mr. Advocate General, after 17,
Lordship,
that's a crucial date for High Court.
20th 20. 21. 21 Saturday, Friday, 21.
All right. A convenient date for both of you.
28, 20. 20. Or 21, can it be on 21? Wednesday. Yes, 21. 21st. In the meantime, we'll file a short. We have already the type copy. We have given a type
Corrected.
copy. Yes, corrected.
Certified to be,
Certified?
not certified, certified by
Filed.
the advocate of having checked it, that it
Yes.
is the correct copy.
Yes. Highly obliged.
Lot of mistakes were there.
Hmm.
So in the original also, I find.
But one mistake which has turned the tables
Yes,
is that not has not been read as not.
yes, yes.
Let's see.
Item 43.
In the whole area is a sub-land lordship.
That
Whole area.
we will
But
see
that has to
that.
be decided, no.
Yes, yes, decide. Because,
Even if it's,
no, no,
all of it is
because
Satra land,
By
it has to be decided.
yes,
Now, there were only 17 bighas of kattas
That's-
which were under dispute.
This
17 bighas, but it was extended
No, no.
to 101.
Can Board of Revenue pass an order that even if this matter is not before me, the entire area, my presumption is that it is Satra land, therefore make necessary changes in the revenue records. That can't be done, no?
Yes. And secondly,
And
2000,
especially when the lands were in the name of the pattadars.
yes. Now,
Process had.
no notice, nothing. 2023, now the state.
who
has
are
come
they,
in.
lordship?
The 2023,
The
they,
issue is who are they?
They were
2000.
descendants of Goswami
Yes,
family.
yes,
They are
yes,
the
they are
descendants.
royalties.
That is we have to leave the will.
So, my lord,
If we leave the will,
2023,
the actual descendants will come up.
2023, they came up a
You have
notification.
such information.
We have everything, lordship. That is why this Assam Assembly constituted a committee and made the survey in all the satras.
Then you don't.
It's a huge issue.
Then you'll be required to give a detailed note.
Yes, lordship. We
2000
do not want to hide anything.
No problem.
Mr. Das, if that is the issue, then Mesa.
It's a very
no.
serious
My
issue
lord-
for our country or for our state.
My lord, all are serious.
All our
2023, there is a notification issued by the state government saying that Nisfikaras is termed as a Miyadi Patta land, and it doesn't belong to the Assam State Religious Charitable Institution. That has been spelled out. So if that be the case, they acquired on the basis of that act, section 15.
Can you file your response before the date?
lordship, that I will do that so that they can also respond if
Yes.
they want to.
All.
Yes.
I'll do that. Highly obliged, lordship.
Item 43.
My lord, we fought, now we'll have a cup of coffee.
Yes.
Going up.
It has the scope of getting an issue to the tune of Babri Masjid type lordship, this case. It's a very serious matter. Highly obliged.
Deeply obliged, my lord.
Yes, sir.
Against the judgment dated 6/9/2024, whereby Honorable Single Judge has refused to enter into the merit on the ground that the period of agreement has expired.
Just a minute, just a minute. Let's come to the judgment first.
Under that page 144.
Mr.
11/154 onwards, my lord.
Give us 1 minute.
Lord.
Mr. Saikia, though we understand that the motive behind terminating the contract after the lapse of the original agreement, after the lapse of the agreement which ended in 2022, motive was your involvement in a criminal case. But then these are not there on record. It is we are not required to lift the veil because it is basically a contract. Contract is
That
lapsed,
is-
it has not renewed.
Look, that is their case exactly, my lord. But
That's what we are thinking at.
Lord, my lord. Now, my lord, my terms of appointment. my
And
lord,
it
the
is not
terms of-
that case where we can apply our minds that, you have brought embarrassment to the organization. Nothing. It's not punitive at all. Sorry, it is not punitive, it is, but it is not stigmatic.
my lord, that will be, my lord, I'll come to that, my lord, the secondly, my lord. Firstly, my lord, in the affidavit what they have filed, they have, my lord, exactly portrayed a case that without, my lord,
We are therefore surprised at the stand of the state while saying all this. There was no need to say all this.
Right.
For the reasons that your services are not required now, we are not, or not even that. You could have been orally told, please go, we don't require you. The agreement has lapsed
My lord, here the case would be a little different here.
because you have worked for 21 years. That is the only difference.
No, my lord, my appointment was after due selection. The terms of my appointment says I have to enter into an agreement. There is no specified period for which it has to be entered. And initially it was for 5 years. For twice it had gone 5 years. Then thereafter they have started to have 11 months or 1 year, something like that. My lord. It is for the entire Assam. My lord. Now, the terms of the appointment, which provides for my lord, entering into an agreement, the last agreement I have annexed. Therefrom, your lordship will find there is a procedure prescribed for discontinuation of the agreement. And it is also governed by the rules specifically made for the purpose.
What does it say?
My lord, if your lordship comes to the my lord agreement, the last agreement, my lord, at page 57.
Yes.
Lordship. Before that, may I take your lordship to the my lord, my appointment first, my lord,
All right.
is at page 55, my lord. Page 55. First general recitation, then second part, my lord, the above named candidate are directed to appear before the district elementary education officer come district mission coordinator of the respective district and execute the deed of agreement for finance and accounts officer in between so and so date invariably. In case of failure to act accordingly, it will be presumed that they are not interested with the assignment and other candidate considered in their place. Then they will not be considered for the post of FAO in future. Now the agreement that has been entered at page 57,
Yes.
it is the last agreement. It was up to my lord 30th November 2022. Now, lordship, serial number 2, that party of the second part shall remain in contact for the from the date of signing this agreement. There is no date, my lord, till so and so date. The party of the first party shall remain duty bound, carry out the works assigned by them first part.
No, but this is covered under one, no? This is covered under one.
No, lordship, this has to be, my lord, read with the other, my lord. Let me read out, my lord, the other conditions also. There is one, my lord. The party of the part shall remain duty bound, carry out works assigned by the first party in accordance with the duty chart of the respective component designated set for the contract period. The party of the second part shall submit yearly progress report on timely implementation of activities in relation to the competent. First party shall make proper assessment on the performance of the second party. Second party shall endeavor and strive for contribution towards the fullest achievement of target, qualitative and quantitative, as set by first party during the ongoing financial year. In case of any shortfall, the second party shall be duty bound to give specific reason, plausible explanation for this same if first party seeks explanation for it. If the written explanation of the second party is found not satisfactory, the first party may ask to improve performance as well as to improve himself herself for the forthcoming financial year in terms of qualitative, quantitative achievement in her duties, or can discontinue the agreement henceforth depending upon the nature and underperformance or misreporting or non-committing attitude to work in mission mode. The competent in charge of the competent shall submit a brief performance report of the employee working in his component every year in a prescribed format to the first party. The first party shall evaluate the performance report, and if any shortfall found, then remedial measures will be taken if required. Then, lordship, the next page, serial number 4, that during the subsistence of the contract, the second party shall be subject to all rules, regulation, bylaws of the Assam Sarva Shiksha Abhijan mission for the time being in force in regard, including conduct and discipline. The first party may terminate the agreement if it finds that the service rendered by the second party are unsatisfactory, or if there is any breach of the terms of the agreement. In such circumstances, it will be open either party to terminate his agreement by giving a 30 days notice to the second party in writing or by paying 1 month's remuneration in advance in lieu of notice. If the first party has to terminate the agreement at any time due to misconduct, insubordination, dereliction of duty, misreporting, misappropriation of SSA fund, or negligence in duty by the second party, the first party shall proceed with in terms of the order number so and so dated 14/8/2025. This notification, which speaks that the principles of Assam discipline and services discipline and appeal rules will be followed. Now, two things here is that by the lapse of the period, automatically does not come to an end. I have to submit my self-assessment report. Then the performance report will be assessed. If something is lacking, they'll give me an opportunity to improve. And after seeing me for the next financial, if I do not approve, then they can discontinue. That is the procedure that has been prescribed. This has not been followed at all. Now, what had happened, my lord? Firstly, my lord, they have issued me the explanation notice that some files are missing. You give me, please explain why. I have submitted my reply saying that I am not the custodian. The custodians are someone else, so therefore you look into it. Then thereafter, they have constituted a 3-man committee. The committee has found one Dipti Gogoi, the accountant, into her account, certain funds were there. And accordingly, report was submitted. On the basis of that report, a so-called notice was issued to me. I have submitted that this allegation, basic allegation was that the mandate which was required to be submitted to the bank has to be signed by the FAO, that is the present petitioner, and the DMC. And there only one signature was there. I have denied saying that this is a fraudulent document, is a false. It is not my signature. In my reply, I have said so also. Now they did not pursue that any further. They have come to the impugned letter saying that because my agreement period has lapsed way back in 22nd of 30th of November 2022. So by order dated 9/6, they have 19/6, they have released me. Now in practice, what happens in the organization, my lord? Notwithstanding the expiry of the period, all the persons are continued because it is a bulk some job to get everything is all the agreement to be signed. And accordingly, everyone is continued. That is also admitted by the SSA. Now, initially they have only, as your lordship has pointed out, they just said that since the term has expired, we have decided not to continue him. And the regulation, lordship has seen that regulation is also applicable. The regulation provides how the performance are assessed.
That's right, Mr. Saikia, you have a point there. But the difficulty is that they have not even said that because of alleged or suspected misconduct. They say that no, we don't want you. After all, this sanctity of contract has to be maintained, no? You are under contract has lapsed, no further renewal.
No, renewal, that process is there. The self-appraisal and the performance, the regulation also. I'll just place
it otherwise. See, if there is a judgment arising from this court only, where a lot of discussions have been made, what is the motive, how to extricate the motive from all this. That happens only when you say that, when the organization says that you are an embarrassment for us, you have made yourself liable for criminal prosecution, you were under arrest, we don't want to continue with. In that case, notice has to be given, your explanation has to be sought, maybe a domestic inquiry has to be conducted, notwithstanding the contract. But for this, we are afraid whether we can go into all that.
As well, my submission would be, the matter while.
Just a minute. Mr. Saikia, you should have shown us the order of termination. No. In view of ongoing police investigation in connection with so and so, is directed not to, not to, this is something else.
There's the termination order.
No,
It is the release
thereby
order.
directed to look into the accounts related transfers signed. Is look and, no, the order will come. Just a minute, further people directed not to allow to process any other, this is suspension kind of. And then 84,
Initial application.
no, who appears for the answering respondent?
SSA is the main party, Malak.
No, where have you told him that it is because of the lapse of the agreement?
Page 83, Malak.
Page 83,
Yeah.
that's the include.
Released from contractual service on account of the lapse of his contract. Yeah. Who appears for the other side?
SSA, Malak. Nayak is coming.
Yes, Mr. Govind. Are you?
Lordship, unfortunately, today we missed this item. In the causeless, Lordship, now I have.
Doesn't
checked
matter,
out-
it will come tomorrow.
Lordship, no.
It will come tomorrow. कल वो judgment के बाद ये लगा. The short issue here is that he was under a contractual agreement to serve. That kept on being renewed for about 22 years, 21 years. There was a criminal case with respect to some misappropriation in the department. He was arrested for a while. There was an inquiry, committee formed. He was not to be found guilty, but somehow the other, he was also arrested but released on bail. Later, he was asked for an explanation. All these are on record. Then suddenly wisdom dawned upon the respondent and said that because your agreement expired in
Yeah.
2022, it has not been renewed, we are releasing.
Yeah.
So whether we would be permitted, whether the courts would be within their jurisdiction to lift the veil and see that it is punitive. It is not only punitive, it is, in that case, the stigma can be read into it because of the background fact. That's what Mr. Saiki has argued.
At the same time, Lordship, whether
Yeah,
it will
in
be
fact, Malak-
appropriate to direct the authority to renew his contract.
No, we can't do that. We can't do that, but you'll have to take him in. Suppose we decide that way and then subject him to the proceeding explanation, the same rules, not with the same rigors.
Principles would be applied.
We can't direct an authority to appoint somebody. Why?
Most if I remember correctly, in this case, Lordship, during the pendency, Lordship, authority decided as your contract has already expired.
There is the same case.
Yes,
You're right. You rightly remember the fact of
yes, no.
it's the same.
Because earlier, I think I appeared in one or two occasions.
Tell us, because there are divergent views of the courts. In many cases, they say, notwithstanding the contractual nature of the employment, if the contract subsists for long years, then it partakes the character of a kind of permanent appointment, and therefore you must give him notice, ask for his explanation, evaluate his explanation, pass it on.
Now, so far as SSA is, I will definitely submit my submission will be not. In this case, so far as SSA is concerned, they have a service, SR, service regulation or something like
No,
that.
there is nothing on record.
And
The
it-
one page, at
SR.
you go through page 83 of the brief. It says because your contract has expired, it has not been renewed.
Yes. So, so far as language is concerned, it is not terminated. You are only released from service.
Only to avoid the procedure of those are prescribed.
But
termination-
before that,
Termination
immediately
has not.
before that was preceded by an inquiry and by show cause and explanation.
So your lordship has rightly said they become,
And so Mr. Nayak, look at it and come back.
yes, that's, yeah.
There are different kind of judgments. Majority of them say that please don't interfere in where the contract has lapsed. There are few of them, including ours, where we have entered into that field.
Yes.
One, we have entered into that field. Yeah. Tomorrow?
Tomorrow.
Tomorrow or after vacation?
After vacation, lordship,
Yeah.
I will get some time.
Mr. Nayak, learned counsel for the respondent, seeks an adjournment in the matter for assisting this court. we have heard Sri P. Upar mein likhna, we have heard Sri P.J. Saike, na? We have heard Sri P.J. Saike, learned senior advocate for the appellant. Mr. Nayak for the respondent, learned advocate for the respondent, seek some time to to seek some wo jo likha hai, to address this. January is sometime till last.
Abhay.
May I pray for 29th?
29.
29 can.
29 January.
Abhay.
Item 44.
May I please, your lordship?
Yes.
My lord, my challenge is to the particular two provisions of Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Act. My lord,
Yeah.
kindly have a look to the
Okay. Okay. So we were basically inclined to accept your submission.
my lord.
We had asked Learned Advocate General to look into the matter. Advocate General
But-
had said that we
yes.
will bring about changes in the rule.
Yes.
Otherwise, rule is very clear, my lord. He is wrongly interpreted the rule, my lord. May go to the, take it to the rule, my lord. Rule 7 and 10 is very clear, my lord.
Yeah,
There
what
is-
is it?
Yes, my lord.
Read.
Page 33, my lord. This is with regard to inter-district transfer, my lord.
Page 33.
Page 33.
Hmm.
The government and the competent authority shall be guided by the following norms in respect of inter-district transfer of teachers. A teachers working in district continuously for 10 years or more can apply for transfer to his or her home district to a nearest contiguous district. So there is requirement of 10 years in case of teachers, and in case of disabled, differently able, my lord, it is 2 years, my lord. And now, my lord, kindly come to page 10, page 35, section 10, my lord. Rule 10. It's a ground for seeking transfer. These are the 6 grounds where teachers can apply for transfer. First one is, my lord, for change of residence due to marriage. For that, my lord, 10 years is not required.
You say that?
Yes,
that
my
10
lord.
years is not required.
Therefore, my lord, kindly
You have rejected his application.
no, my lord, kindly come to E, my lord.
Yes.
Subrule E. For the reason as mentioned in section 7.
Hmm.
Section 7 refers to 10 years, my lord. So this is an independent, my lord. This ground is independent.
The teacher may seek transfer only on the following ground for the reasons as mentioned in section 7. Therefore, following- No.
This is
No. Therefore, the Learned Advocate General said that after reading of it, that he would get back to this court. I mean, there is a change. Or you say?
yes, my lord. That is, in fact, we have discussed it, my lord. We have discussed it, my lord.
The Advocate General is sitting behind.
So what my learned friend is submitting is correct, lordship. It is a additional criteria.
All right. So have you applied for?
He got it.
My lord, already I am transferred, man.
There is no grievance left.
Don't press it then. Don't press it unnecessarily. Academic matters, we are not interested. This is no 140.
Lordship, may we please to
Okay.
close it, lordship.
Since the grievance of the petitioner has already been redressed, come on. What is your name?
Yes, Alim.
Mr. So-and-so, learned advocate for the petitioner, does not press this petition any further. Dismissed as not pressed.
On the last occasion also when I appeared, lordship, at that time, prior to that, he got it.
Okay. When he got it, they got it. Then they are not insisting for the cap of 10 years.
No.
Great.
My lord,
I think this is good enough.
Yes, ma'am.
We don't require any affidavit from them.
In additional case, lordship, 10 years can be another criteria for transfer.
For general transfer, I
For-
want a transfer for convenience of
Yes.
my children.
Yes, in that
I will
situation.
seek a transfer, but I can only make that application after
After
10
10,
years.
but for those emergent situations, there's a different criteria.
No. The petitioner perhaps was under the apprehension that his application is not being processed because he's short of 10 years.
He may be thinking, but it was not the case.
No, that's all right. The state, it shows because his application has been accepted.
Yes, without any interference of the honorable court. Prior to that, much before.
my lord. I am obliged, man.
Highly obliged.
Item 46.
May I please, my lord, my learned senior.
Please, my lords.
Yes. Yes, Mr. Hegde.
My lords,
Yes, continue.
please, my lords. My lords, in this matter,
You'll have to upgrade your systems.
challenges
Mr. Hegde, can you
the
hear us?
detention. I have a full written submission, which my learned friend
Mr.
can
Mr. Hegde, can you hear
hand
us?
over, but
Mr. Hegde, can you
there
hear
is a
us?
development. There is one development. I'm sorry,
We
my
can't
lord.
hear you.
Can my lords now hear me? Can
Tell
my
him on-
lords now? I can
Sir,
hear
sorry, your
you.
voice and video is not clear, sir. That is not coming, sir. There is a pause in your video as well as in audio, sir. Yes, sir, now it's coming, sir.
Now
Please,
it's
my
okay.
lords, can my lords now hear me? You, your lordship can't hear me?
I can hear you now.
Just 1 minute, my lords, let me. Please, my lords, if my lords can now hear me clearly, I apologize for
No, it's all right.
talking to
The system's fault, not Mr. Hegde's fault.
please, my lords. My lords, in this matter, I have a detailed written submission, which I could place before your approval. But there is one development. My submission relies largely on a judgment of the Calcutta High Court Division Bench. Where in similar situations, people who had
No,
been.
you're not able to hear. It is not, the voice throw is not
It's
consistent.
not audible for me also, Lord.
Nobody can hear you. Continuously, you can't be heard, though you are visible.
Clarity is not
Give me
there.
1 minute. Your
Mr.
lordship, give me 1 minute.
Mr. Hegde, you will have to have your system upgraded because on the last occasion also, the matter could not be heard because your system was not correct.
Would your lordship give me 1 minute?
If you can see us, we are shaking our hands and
Okay, okay. Also, sir. Now the audio is also.
Mr. Bhuyan,
Sir,
ask him for
my
another
lord.
date when he'll have an upgraded system at
Yes,
his,
yes.
at his house or office, and then we can hear.
My lord, actually, my lord, my instruction is that, my lord, there is a matter connecting this is pending before the Honorable Apex Court also, my lord. So therefore, the learned senior counsel has instructed me to, he will pray for an adjournment, my lord,
Yeah.
and my lord.
All right, as prayed for on behalf of the petitioner, let this matter come up for consideration sometimes in March.
My lord, can it be in?
I'm sorry, my lords, am I clearer?
When you start, we can hear you, but after two lines, it breaks. Now again, it has discontinued. Now, Mr. Hegde, if you can hear us, just hear
I'm
us.
sorry, my lords.
Now, if you can hear us, we are adjourning the matter for some time. Say, indicate your convenient date, we will fix it on that day. We can't hear you even now.
Can it be in the last part of January, my lord?
No, everything can't come in
Then,
January.
my lord, February 1st week.
February 1st.
My lord, my lord.
February 1st. Tell him on phone.
Yes, my lord, I will inform.
Deeply obliged.
5th of
March.
He wants
sorry.
February.
February, sorry. 5th of February.
My lord, 5th of February, sir.
5th of February.
Obliged, my lord, highly obliged.